My lord, sorry to mention item number 2. Can it be taken up after some time?
Yes. May it please, your lord. Well, item number 6, my lord. The LCR was called for, but that has not been received. Yeah,
Not received.
not received, my lord. Actually, one problem was there, my lord. Lordship had called for the special case that what NDPS should be there by. My lord, Lordship had again called for the, my lord,
I'll
Sir-
just write stat codes record. That is sufficient.
well, NDPS, the word NDPS. NDPS number 59/20.
Call for a scan copy of the trial court record of NDPS case number
59 of 2023.
along with the scan copies of the CD. List the matter on.
I read-
তারিখ এটা দিয়েছেন first week of April.
I'm obliged.
Item number 18 of
18.
But the matter has already been settled and they have withdrawn, SBI has already withdrawn the case
Hmm.
and payment already given by my client.
Hmm.
This matter is infructuous, so it may be dismissed on withdrawal.
Learned counsel Miss M. Bora is present for the
Petition.
এটা কি হয় কারণ আসলে orders are no for the petitioners about anybody from the banking side.
Bank has called me and they said that we won't appear because
Hmm.
already settled,
Hmm.
you can withdraw the.
The learned counsel for the petitioner submitted that the matter has been amicably settled between the you for the petitioner, no?
For the petition.
Has been amicably settled with the respondent bank. The learned counsel for the petitioner submitted that that as the matter has become infructuous, she has prayed to withdraw this
on
dismiss.
withdrawal.
Okay, dismiss this application. You were directed to pay something. You were directed to pay some amount to the bank.
We had already settled. It was
Settled.
around 40 lakhs
Uh-huh.
settled between the parties. It was a loan for the, and they had moved the DRT for
Hmm.
recovery.
Hmm.
So ultimately they had settled both the parties.
Petition is dismissed on withdrawal
Much of it.
as the matter has been amicably settled between both the parties. Any I?
No, no.
I was withdrawn.
May I please proceed? But I beg to mention item number 39 on behalf of Mr. S. Samaria, Lordship. I have already informed the other side, Lordship.
39.
39. Hearing matter. I have already informed the other side, Lord.
Learned counsel Mr.
MM Zaman, Lord.
MM.
Zaman, Lord. On behalf of Mr. S. Samaria, Lord.
MM Zaman on behalf of learned counsel Mr. S. Samaria, representing the respondent number 1, with the consent of the other side,
Lordship.
PK Cholu has prayed for withdrawal or has prayed for adjournment. List the matter when do you want?
Next week, Lordship.
After 1 week.
Lord.
We're back to mention item number 40. We have taken consent to the other side. Any has some difficulty. Can it be fixed on 25th March?
Hmm.
Item number 40, Lord.
40.
40, yes.
Learned counsel Mr.
D. Mazumdar, Lord.
D. Muzumdar, with the consent of the other side, has prayed for adjournment. List the matter after
On 25th, Lord.
on 24th April.
20, much obliged.
May I please?
Hmm.
I beg to mention item number 22, Mike. I've taken the consent from the other side, my lord.
I appeal for the respondent in item 22.
Hmm.
My lord, I pray that this matter may come up after 2 weeks.
Learned counsel Mr. A.K. Gupta, with the consent of the other side, has prayed for adjournment. List the matter after 2 weeks.
But there is interim order that may
Interim order shall remain in force till the next date of listing.
oblige.
Your Lordship, I'd like to mention item number 3. I'm representing the Engaged Council for 1, 2, 3. Your Lordship, the Engaged Council, due to his ill health, is not able to be present today. So, I beg,
Learned Counsel, Mr.
M. Kashyap.
M. Kashyap. You are M. Kashyap.
I'm an, Your Lordship, I'm N. Nominal Bhuya. I'm representing the
N.
youngest
Bhuya.
council. Yes, Your Lordship.
Learned Counsel, Mr. N. Bhuya, on behalf of Learned Counsel, Mr. M. Kashyap, representing respondent numbers 1, 2, and 3, with the consent of the other side,
Yes, you consult the
with the
other side.
consent of the other side, has prayed for adjournment, list the matter after
On 27th March, Your Lordship,
27 March.
Yes, Lordship.
On 27 March.
PA may continue. There is a stay order.
Okay.
Sure.
Interim order shall remain in force till then.
Obliged.
Yes, Your Lordship.
Ma'am, the Lordship. With the consent of other side, Lordship, I beg to mention item number 4, Lordship. Matter will be passed for the Lordship.
Learned Counsel, Mr.
B. Devi, Lordship. On behalf of petition,
P. Devi, on behalf of Learned Counsel, Mr.
B. Devi,
Yeah, on behalf
Mr. A.C. Sommer.
Learned Counsel, Mr. A.C. Soma, representing the petitioner, with the consent of the other side, has prayed for adjournment. List the matter after 1
After
week.
3
3 weeks. List the matter after 3 weeks.
months.
May it please your lordship. Lordship, I beg to mention item number 60.
Hmm.
In this matter, the appellant has expired, as such we need to file a substitution petition.
Hmm.
6
Learned Counsel, Mr.
R. Dekal.
R. Daka has prayed for time to file substitution petition as the appellant has passed away. List the matter after
2 weeks.
2 weeks.
Much. May it please your lordship. With the concern of the other side, I beg to mention item number 33.
Hmm.
On behalf of, I'm praying on behalf of the leading counsel, Mr. R. Sharma. He could not come today due to some personal difficulty.
Okay.
The matter
Learned Counsel, Mr.
KJ Hazarika.
K.J.
Hazarika.
Hazarika, on behalf of Learned Counsel, Mr. R. Sharma,
R. Yes.
on behalf of Nalaga, has submitted that the Learned Counsel, Mr. R. Sharma, on behalf of Kateri Lihiria, has submitted that the Learned Counsel representing the petitioners, Mr. R. Sharma, is not present today. List the matter after 1 week,
2 weeks.
after 2 weeks.
The interim order shall continue.
Interim order shall remain in force till the next date of listing.
Grateful, Lordship.
Lordship, I beg to mention item number 14, Lordship.
Hmm.
Kindly pass over the matter after 2 weeks.
Okay. Wonderful.
Pass over for the day. List the matter after 2 weeks.
Obliged.
Item number 1.
But item number 1 and 8 out of the same
Item number
FIR,
1 and 8.
8, madam. 8 is AB and it is my BA.
You have the CD?
So now, my lordship, idea, madam, one thing we could not we forgot.
Yes, yes.
Idea and lordship rejected, madam. Actually, other advocate was there, we are not there, madam. So actually, we got the copy, madam, we could not annex it, madam.
In item number 8, scan copy was for that has perhaps not received.
One additional affidavit also filed in item number 8, madam. That may be also, madam.
There is an office note as per dated 10/3/2020.
Madam, your lord kindly record, madam, we could not annex that one. We could not annex.
Sorry?
Your lordship, what are we could not
Okay,
annex.
okay, okay.
Today is 102 days. First charge sheet is filed, madam, in this case.
Sashi has been filed.
First charge sheet. Only postmortem report has not been received. So you kindly have a look to only one line, madam. Page 24. Page 24.
Yes.
Yeah, page 24, madam, Roman 9, Roman 11, madam.
Hmm.
The postmortem, the final postmortem report examination of the deceased has not yet been obtained. Yet, during investigation, there was found sufficient evidence against the arrested accused person. Present petitioner is also there, madam, 4 persons. From the above fact, a prima facie case is found well established against the aforesaid accused persons, Muhammad so and so, the 4 persons including the present petitioner. Hence, I do submit the charge sheet of the case against the aforesaid accused under the section of law to prosecute them in the honorable court. Further, it is to be mentioned that supplementary charge sheet will be submitted as per provision of section so and so after receiving the final PM examination report. The witness mentioned in so and so will report. So whether, madam, your lordship can consider, madam, everything is complete, madam.
Yes.
Now witness also been examined, whatever exists. only postmortem report for
How many
that.
witnesses are examined?
One, no, not a single. Examined 161 statement taken all that. What I am saying, madam, about 17, total matter PW 17, madam.
Hmm.
So charge not framed, part charge sheet filed. So whether further custody required, I am only on that, madam.
Hmm.
Everything is complete, my other way, madam. Your lordship may consider, madam, what is I am saying.
Let the scan
So far,
copy
this
be called
item.
for, Lordship, and that
Scan copy, I think it is here, I think.
it is not, perhaps it is not there in item number 8. If it is,
Okay, we'll need the scan copies.
So it is here, madam, here, but I mean,
I have, as the officer 10/3/2025, Lordship, it is not there.
Okay, we'll call for the scan copies.
Yes.
Then, madam, short date, madam. It is here, I mean, go, madam.
Yes, yes. Call for the scan copies of the trial court records along with the scan copies of the CD. List the matter on. So short date এটা দি দিয়ক 21st of March. এটা নোট এটা কৰি থৈ দিছো হেৰি কৰি দিবা নোট এটা কৰি থৈ দিছো একে অৰ্ডাৰ এইটো নোট এটা কৰি থৈ দিছো
So 1 and 8.
এইটো এক নম্বৰ এক নম্বৰ নি
About 8, madam, I have put an additional affidavit that may be tagged in that, madam. Your lordship,
এইটোত এক্সট্ৰা এটা লাইন ভৰাই দিবচোন এডিশনাল এফিডেভিট has been submitted
that may be tagged.
on behalf of the petitioner.
Petitioner. No.
এইটোত এক্সট্ৰা এটা লাইন ভৰাই দিব এইটো
Additional affidavit to option is okay.
First of
No,
office to
yesterday-
place the office to place the affidavit on record.
Madam, obliged to. 21st, madam,
21st.
obliged to.
Item 5. Item 4.
Mm.
I was expecting item 2.
Hmm.
In this case, Lordship, earlier called for some status reports, my lord. Yeah, in this case. And my lord, petitioner earlier approved my lords, but his bail application was rejected. We have annexed it at page 51, my lord. Now, my lord, I'll briefly place the facts, my lord. In this case, my lord, from 2 persons and from a vehicle, my lord.
From 2 persons.
Yes, 2 persons, my lord. Namely, my lord, one Abdul Kalam and one Shaju Muhammad, who happens to be the driver of a vehicle, my lord. The police recovered.
Saju Moha, who is the driver?
Shaju Muhammad, my lord. As per FIR, my lord, Shaju Muhammad. One Shaju Muhammad is the driver of a vehicle, my lord.
A contraband was recovered.
Yes, my lord.
How much?
It's 1.562 kg of suspected heroin, my lord.
1.562.
62.
All right.
1.5 kilometers.
Hmm.
So, my lord, if I just take your request your lordship to page 15, where my implication starts, my lord, in the FIR, my lord.
Yes.
Page
Page 15.
Yes, my lord. Second, it's a second paragraph from bottom, my lord. May I read, my lord?
Yes.
Yes. Moreover, during further investigation, the apprehended accused person, Muhammad Abdul Kalam, had revealed that they had brought the contraband substance from Mizoram on the instruction of Abdul Hasib Khan. That is the present petitioner before your lordship. And so. As such, the drugs were also to be delivered to him, and he has admitted the entire task was bringing the contraband substance from Mizoram to delivering them to Abdul Hasib Khan and Muhammad Atik was carried out by them on their instructions. So this is my implications, my lord, that I because on the instruction the 2 apprehended accused person brought that contraband substance. Thereafter, my lord, I was arrested on 30/3/2023 from my residence, my lord.
13/3?
30/3/2023. 30th of March 23. Yes, ma'am.
30th of March.
Yes, ma'am. I have an next, my lord, forwarding report.
You arrested from your residence.
Yes, my lord. From my residence, I was taken into custody, my lord. And thereafter, the prosecution, my lord, submitted charge sheet on 20/07/2023 against 5 accused persons, my lord. 2 apprehended accused persons who were at the spot, my lord, and thereafter present petitioner along with one another, and one person, my lord, Atikur Rahman, he is not absconding. And because of that, my lord, till date, the matter is at the appearance stage, perhaps, my lord, because my learned senior has, my lord, colleague has.
My lordship, on 5/2/2025, the matter was split up because one of the co-accused was found to be absconder, lordship.
Matter has been split up.
Split it up. And thereafter, on 19/9/2023, lordship cognizance has been taken.
Yes.
And now the case is standing at a stage of production stage.
Production stage. Yes, Lordship will find you, page 51, Lordship has, when rejected, Lordship,
On when was it split up?
Lordship
Five?
on 5/2/25. A status report was called for, that is there.
my lord, in my two submissions, Lordship, I kindly consider. One is, my lord, that confession is not a single, my lord, offending material was recovered from the custody of the present petitioner. And secondly, my lord, I'm in custody for last 713 days, my lord. 15 witnesses are to be examined in this case, my lord. I pledge before my lords to face the trial with any stringent condition. I'm local resident, my lord. I'll not
More
evade-
than 2 years.
Yes, more than 2 years, my lord. And if your lordship permits me, I'm relying few of the judgment. One is, one lordship has considered, my lord, the prolonging. That is a very recent, my lord's permit, my lord. Yes. Very recently, lordship has, my lord, considering the prolonged incarceration, my lord.
Okay, no.
No, 30.
I'll just see what is the thing recovered.
My lord, in this case, in present case, my lord,
Hmm.
yes, it is recovered, my lord, 1.5 kilo of suspected to be heroin, my lord.
Here in this case where I have granted bail,
My lord,
similarly situated case.
my lord, if I am not wrong, my lord, I have, there are perhaps 2 kgs of contraband substance was directly recovered from that person, my lord.
Hmm.
Even though lordship was pleased to uphold Constitution, Article 21, my lord. And in this case, my lord, from the present petition, not a single offending material, my lord, was recovered.
It's an organized crime, Lordship. So it is not necessarily required that contraband has to be recovered from the petition. If he is somehow connected, then he is also.
It was not recovered from the conscious position of
No,
the petitioner.
no, madam. That is very much clear from the FIR itself, madam.
Hmm.
And in fact, if your lordship, when he was arrested, I just take your lordship to the charge sheet, my lord, what was recovered from him.
Okay, it is there in the FIR.
Yes, Caesar, yes.
This co-accused was granted bail by the Supreme Court. That is why I have granted bail.
Yes.
Ubaidullah, madam.
That this case, I have forgotten to mention that co-accused was granted. Here, the co-accused was granted bail by the Supreme Court.
In this Ubaidullah, my lord,
Yes. Somehow I have forgotten to mention, but
my lord,
here,
that Dhirendra, because
yes.
no, Dhirendra, my lord, one of the co-accused, I appeared, my lord, in Dhirendra, before my lords.
Hmm.
So
He was granted bail by the Supreme
yes,
Court.
Dhirendra was, my lord, granted bail, so lordship considered the
Yes,
co-accused bail
yes,
application.
yes.
Because I appeared.
I had to consider because Supreme Court had granted
Yes.
bail.
I'm relying on lordship, my lord, own order.
No.
That is why.
3788, my lord.
There, co-accused was granted bail. I have forgotten to mention. Recently, I have passed this order. Somehow I skipped this line.
Lordship,
I had to mention it, but I have skipped this line. But I remember vividly, I had to grant bail because co-accused was granted bail.
No.
Otherwise, in 1 year, 10 months, I'm not granting bail to persons carrying Yaba tablets.
Yes.
Never.
my lord, he was not carrying, my lord, lordship, he was not carrying, lordship has seen from the FIR and charge sheet, even charge sheet also, my lord. Page 34, lordship, kindly peruse for a moment, my lord. Page 34. What has been recovered from his possession, my lord, Caesar list. Caesar.
No. Not today.
What you have opposing it?
No, not now.
Then any other day, my lord.
Yes, maybe any other day, not today. I can fix it for order, but if you want an order, then I'll reject it today.
some other day, my lord, if charges are paid by fund, if, then we can also, my lord, to place the order before your lordship.
Already cognizance has been taken.
Cognizance is taken, lordship, way back in the year 2023 itself, page 51, 52, my lord.
No, 19/9/25.
Cognizance is taken
Or
19/9/23,
19/23.
23, my lord.
Are you asking for adjournment? I can grant adjournment.
Then, my lord, then I also do some research, my lord, on that part of.
No, this is true, absolutely true.
Yes, my lord.
Somehow I skipped a line. I remember it. This is only last month I have granted bail.
Yes, yes.
So I remember it because I have been taking up civil benches.
Yes.
So I remember each and every order now I pass in bail petitions. I remember it vividly.
Lordship has.
That as the co-accused has been granted bail, I cannot hold the other co-accused back.
Dhirendra, my lord.
Supreme Court has granted bail.
Yes, my lord. Dhirendra, which I am referring, the co-accused I appeared before my lords, and lordship has granted bail to the co-accused because Supreme Court granted.
Yes, that you had appeared. So you will know better.
Yes, co-accused, my lord.
You will know better. This is the reason why I have granted bail. Somehow one line I have missed. To mention that the co-accused was granted bail, so I have granting bail. Maybe I have dictated, but somehow that line got missed.
No, in that co-accused bail application, my lord, where I appeared, lordship has remembered. Lordship has written that line.
I have written.
Yes. I can produce them. But in that case, my lord, 3788, that I don't know, my lord, I don't have that knowledge. That they are also co-accused appeared. Perhaps not appeared, my lord. Co-accused did not approve, my lord. So far, I know.
Maybe I'm mixing up the names. I think so.
I'll also, my lord, I'll also inquire.
I'm giving you a short date.
Yes.
Yes.
Other way also lordship at page 44, the search statement. Lordship at Roman 7, lordship, I think.
No. Here I have granted bail because trial has not commenced.
Yes, my lord.
That case was not split up.
Yes.
That case was not split up. Trial has not commenced. But here situation is different.
Yes, lordship.
So on that grounds I'll reject it.
Lordship, when we come to lordship.
Lordship, then, my lord, fix a time frame, my lord, 2 years.
44, lordship. Roman 7 point number.
Page 44.
Yes, the last line, lordship. Last 2 lines. Has the lordship got it? Roman 7 point number. Page 44.
Yes.
Yes, lordship. I'm reading the last portion. Suspected heroin were seized from the actual possession of the accused, namely Abdul Hasim Khan and Abdul Qadir. So conscious position from their conscious position.
No, then my lord, let me make my submission. That it is very much clear from whose possession it has been written. Now the prosecution itself is, my lord.
This is the charge sheet?
Yes,
Yes,
my lord.
doctor.
The charge sheet has mentioned, so we cannot contradict the charge sheet at this
No,
stage.
it is,
At
my lord,
this stage,
it is, my lord, their document, my lord, where
It
they.
is mentioned the charge sheet and you cannot contradict.
Caesar list direct, my lord, the Caesar list directly say, then lordship kindly, lordship.
He was arrested from his house.
Yes.
So while his house was searched,
Yes.
maybe
Yes.
during investigation,
Yes. My lord,
maybe not the same contraband which was found in the truck.
then
Maybe something else was found.
definitely Caesar list would have mentioned that matter. If for that reason, my lord, kindly come to page 22, my lord.
Page 22.
Yes, the that is, my lord, property descriptions, my lord, what are the things recovered by the investigating officer? That is the 121 number of soap cases. Now, column number 5, from the position of arrested accused person Abdul Kalam and Shaju Muhammad.
Yes.
Yes, the contrabands were, my lord, recovered from them, and now, my lord, it is Caesar list number 2 at page 26, my lord. The documents which were relied upon by, yes, my lord, page 26, lordship has got it.
This is from these two accused only.
Yes, ma'am.
From the position of this person.
Yes.
No, the seizure list number 2, there is something from the possession of Abdul Hasim Khan also.
Yes, Caesar is number 2, my lord. One, see, kept small a.
Nokia
one,
mobile, yes.
yes, my lord. Nokia mobile was received.
Nothing
seized.
more than a Nokia mobile.
Yes, ma'am. That is the thing.
Yes, yes.
It is
Sashit is self-contradicting. Yes.
Had there been any kind of, my lord, offending material recovered from his possession, definitely, my lord, investigating agency would have mentioned it.
Yes, yes.
Two years, my lord, in custody. And still, my lord, there is a very bleak chance of
1.5 kgs of heroin.
yes,
Yes.
yes.
Charge has been submitted after
Yes.
thorough investigation.
And cognizance has been also taken.
How old is he?
39 years, my lord.
Age also, you see.
Yes.
Yes, 39 years.
Very much conscious.
Yes.
Age also, not even 25 years, 39 years. I'm rejecting it. But Learned Counsel, Mr. M.H. Hurri,
Yes.
for the petitioner. Abdul Hasim Khan, Muhammad alias or Muhammad Abdul Hasim Khan, Hasim, ever Hasim, who has filed this application under section
483.
480.
483 of the BNSS 2023 with prayer for bail as is behind bars since 30/03/2023 in connection with special NDPS case number 24 of 2023 arising out of Ratabari PS case number 92 of 2023 under sections 21C, 25, 29. It is submitted on behalf of the petitioner that earlier he has approached this court and his prayer for bail has been rejected. Full stop. The contraband, which tantamounts to 1.562 kgs of heroin, was seized from the possession of Abdul Kalam, no?
Yes, my lord.
Abdul Kalam and Saju
Muhammad.
Muhammad, driver of the vehicle. Full stop. The petitioner was not present at the time when this vehicle was intercepted. Vehicle or number 2, AS, when this vehicle
AS11 EC.
IE लिख लिया, Tata Intra bearing registration number AS11 EC 2082
Yes, my lord.
was intercepted. Stop. It is submitted that the petitioner is behind bars for more than 2 years. Trial has not yet commenced. Full stop. It is only because of the abscondence of a co-accused, which has been procrastinating the trial. Full stop. The petitioner's incarceration without trial tantamounts to infringement of his right to personal liberty. The learned additional PP has raised serious objections stating that the charge sheet clearly reveals that there is a prima facie case against the petitioner. The argument of the learned counsel for the petitioner, Miss S.H. Bora likhi diba de, third learned counsel, learned additional PP Miss S.H. Bora for the respondent's state. It continue. The argument of the learned counsel for the petitioner that the petitioner cannot be incarcerated solely on the statement of the co-accused cannot be accepted at this stage as charge sheet has been laid against him. Full stop. At this juncture, trial has commenced. At this juncture, trial has commenced now. The matter, this case against the absconding accused has been split up and separated. I have considered the submissions at the bar with circumspection. It is true that on finding a prima facie case against the petitioner, charge sheet has been laid against him. this is a case of transportation of 1.500 and how much? 562 kgs of heroin wherein charge sheet has been laid against the petitioner. Trial has commenced. No, it took a trial has commenced to Katidia. The rigors of section 37 of the NDPS Act restricts the bail application, at least at this stage. To stop it. It cannot be considered at this juncture that the petitioner's right to personal liberty has been curtailed, despite the fact that trial has been progressing at snail's pace, SNAIL apostrophe S, snail's pace. Considering all aspects, petition with prayer for bail is rejected at this stage. However, the petitioner is at liberty to file a subsequent bail application if trial is procrastinated any further. एकदम beginning of लिखी दिवसन petitioner submission और रहता है. It is also submitted that there are 15 witnesses enlisted in the charge sheet, and it appears that the conclusion of trial and the conclusion, and it appears and the conclusion of trial appears to be remote. So hey, petitioner submission of paragraph to Bhai. Already at this stage, the trial court is directed to expedite the trial for speedy disposal of this case.
Deep unit.
In item number 8, the case number in the top title has been wrongly typed. I may be allowed to correct the thing.
Yeah, you can correct. You will have to approach the registry with an amended first title.
Item 7.
This application is also under 483 lordship.
Mm.
300 more than 366 days in trial. Cash sheet has already been laid.
Mm.
And on the last occasion, lordship was pleased to hear me and was pleased to call for the case diary lordship.
Mm.
Now lordship, here what has happened?
Mm.
The contraband has been recovered from a DI van lordship.
Mm.
Now these persons were, two persons were the passenger lordship, one was the driver. Now this was not recovered from any secret chamber lordship. Kindly see.
Mm.
It was lying open. So they were not knowing about it. I don't know what is there in the case diary, but the
Case diary or case record?
case record. Case record. Charge sheet has already been filed, lordship. Charges has already been framed. There are 10 witnesses, lordship. I am ready to face the trial, lordship. If I am at this stage not given bail, lordship, then I cannot prepare for my defense, lordship. I have to prepare for my
What is the contraband?
Contraband is ganja, lordship.
How much?
25 kg,
5
lordship.
kg lordship.
25
25 kg point 855 grams.
25.230 kg. That is the suspected ganja as per the FIR, lordship. FIR and the forwarding.
I have rejected this bail petition earlier.
Yes, yes, sir.
I have rejected.
Yes, lord.
Section
This
29 is
this is the second bail application.
So what is the intermediate quantity?
lordship, it's 5 kg.
5 kg intermediate quantity. And commercial quantity is
20 kg.
20
20
kg.
kgs.
20 kg.
Intermediate quantity is 5 kgs or 10 kgs? So,
5 kg.
Intermediate.
so commercial quantity is 20
20
kgs,
kg.
5 kgs above commercial quantity.
yes.
Not at this stage. Not at this stage.
Let it be kept pending, lordship. Let the trial progress little bit. Let us see what.
Learned counsel, Mr.
A.
A. Bhattacharya has prayed for adjournment.
Lordship.
List the matter on 2nd April.
Second, some personal difficulty somewhere else, lordship. Either 1st April or 3rd April. 4th April.
4th April.
Diploma.
Finding item 2.
May it please your lordship. My lord, I take your lordship to page 53.
Without CD?
My lord, page 53.
Okay.
Your lordship has rejected it, but in the last portion at page 57, your lordship will find, as said, because nothing was recovered from me. Only thing the vehicle.
This is a capital trespass case or
No, my
NDPS.
NDPS.
Let us call for the scan copies of
Madam.
call for the scan copies of the trial court record along with the scan copies of the CD. List the matter on.
Maybe a short date, madam, because.
Yes, yes. Yes. 21st March.
Madam.
Item number 9.
May it please, Your Lordship.
Mm.
This is the regular.
Other
check.
side?
No, madam.
Oh, RSA.
RS.
Oh, order rule 11, rule 11.
Yes, sir.
Okay.
For admission.
Caveat?
My lord.
No caveat also.
No. My lord, the appellant
Hmm.
was the plaintiff, my lord. Simple facts, my lord.
Hmm?
Yeah. Facts are simple, man.
Hmm.
He was the plaintiff, my lord. He entered into an agreement for sale
Hmm.
with the defendant number 1
Hmm.
for purchase of a plot of
Twice
land.
rejected, same. Twice
Twice.
dismissed or once dismissed or once
Both
allowed.
are decreed, my lord. Decreed, but the
Decreed.
thing is that, my lord, the court did not allow specific performance, but simply directed the defendant to return the money. When, my lord, both the courts have said that yes, the agreement for sale was done, but instead of, my lord,
How much? What is the agreement for sale?
75,000,
75,000.
70,000.
That land
Land 1 bigha, 1 kata 5 less
from which place?
from my Borpat.
Huh?
Borpat.
Bopera Gaon. 75,000. What type
My
of
lord, it is
agreement of sale
2010,
is this? Huh?
2010.
2010?
Yes.
In a city or in the
In
village?
village probably, my lord.
Huh?
Village, my lord.
Village.
Yes. So defendant number 1 says that he never entered into any agreement for sale with the plaintiff,
Hmm.
but he entered into an agreement for sale with defendant number 2,
How much was to be paid? More?
3,000. And both of them even
What
applied
kind of land is this? 80,000? Huh?
probably when agricultural land.
Agricultural land.
Probably. So he says that he entered into an agreement for sale with the defendant number 2. Now the court, the trial court did not believe his version. Defendant's version court did not believe. Court believed that yes, he entered into an agreement for sale with the
Let
plaintiff.
us go through the operative part of the trial court judgment.
Yes. Lordship will kindly see. If your Lordship will kindly see the prayer portion of our plain first, madam.
Which part?
Plain,
Page?
plain. At page number, my lord, 19. At page number 19.
Hmm.
We simply sought for a decree for specific performance of contract directing the defendant to execute the sale deed. Simple prayer, madam.
Hmm.
The defendants filed counterclaim, madam. Defendants filed counterclaim.
Prayer portion, page 19.
Yes, prayer portion. These were our prayers, madam.
Decree for specific performance
Specific
of
performance of contract.
Of complainant decision, COMPT,
It should have been contract, madam.
directing the defendant to execute the sale
by
deed.
transferring the suit line in favor of the plaintiff.
Hmm.
Now, Lordship will kindly see page number 29. They filed a counterclaim. These are their reliefs, counterclaim.
Hmm.
What they have prayed is that the decree be passed that the plaintiff should be dismissed. Decree be passed that the defendant Mohibul Islam never executed any agreement for sale in favor of plaintiff and never filed any joint petition for sale permission to obtain sale permission of land to the plaintiff. And for
Which one? Which one? Page 29?
29, prayer portion B.
B,
Last-
yes.
Decree be passed that the defendant Mohibul Islam never executed any agreement for sale in favor of the plaintiff and never filed any joint petition for sale permission to obtain sale permission of land to the plaintiff, and for declaration that Mohidul Islam only executed the agreement for sale of the land to the Kulsum Bibi on 1/4/2010. Kulsum Bibi is the defendant number 2. Now I'll take your Lordship to the impugned part. That is at page number 49.
Where is the harm in returning the money? You return the money.
Normally, my lord, when money is usually returned, my lord, if the defendants claim hardship, my lord, say for example, they only have one land, my lord, one plot of land. If they have to, my lord, transfer the land, my lord, then they will be in hardship. Those things will have to be specifically pleaded in the written statement. That plea will have to be taken. in this case, they did not take any such plea. Their plea was that, yes, we have made an agreement with a different person. Court did not believe that part. Now, if the court has believed our part, my lord, then definitely, my lord, the logical conclusion was that agreement for sale should have been directed, man. That specific performance should have been directed. Court did not do that. That is our grievance. Lordship will kindly see the order part, my lord.
Page 49, no?
49 is the discussion, my lord. Page number 55 is the order.
Page 55.
55.
Yes.
In the result, the suit of the plaintiff is decreed on contest with cause. Suit was decreed. Counterclaim of the defendant is dismissed. So counterclaim dismissed means all of their minor claims and reliefs were all dismissed. They did not prefer any appeal against their counterclaim. Defendant did not prefer any appeal. So we preferred an appeal, my lord. The judgment of the appellate court, my lord, is at page number 74. And the discussions, my lord.
So it's okay. Defendant did not prefer any appeal. It's
Yes.
okay because against the counterclaim dismiss,
Yes.
they are asked to pay the money back, return the money.
Yes.
So
Yes.
they did not prefer any appeal.
They
That
did
is
not
why.
prefer any appeal.
So they did not prefer because they are asked to return the money.
No, one of the thing is that their claim is that for not allowing the suit of the plaintiff is that they have already entered into a separate agreement. Their case is not that they have hardship or they have their amount was less. If it was like that, my lord, at the time of execution, the amount would have been very less. Then also, my lord, it would have been a separate issue. They did not take any such plea. Their only plea was that no such agreement was executed with the plaintiff, but a separate agreement was executed with the defendant number 2. That part was not believed by the court below. Their counterclaim was dismissed. But our claim is, since our suit was decreed and our main prayer was that this specific performance should have been done. So, my lord, the court, my lord, without any reason, my lord, arbitrarily, my lord, ignored that part. That is our case, my lord. If the lordship will see the substantial question of law, my lord, which we have.
No. I'll have to go through the order a little bit.
My lord.
What is the reasons assigned for coming to this decision? Please
Yes.
read that part of the.
Yes, at page number 49.
Yes, please read it. Only the relevant portion is
Yes,
sufficient.
yes. My third line, my lord.
Hmm.
Moreover, the version of the defendant that such document was converted into a deed agreement after the signatures of the defendant are taken on a blank stamp papers for a different purpose and also goes without being substantiated. Hence, such onus of proof on the part of the defendant remains without being established. Consequently, it reveals from the perusal of such deed that such deed is a valid deed of agreement whereby both the sides have agreed to execute a sale deed as regards a plot of land as mentioned in the schedule of such deed. The defendant number 1 denied to take sale permission, but exhibit 2 reveals that the sale permission was obtained by the defendant number 1. The defendant has failed to prove that exhibit 1 was fraudulently procured. So, court has given a finding that the defendant has failed to prove that exhibit 1 was fraudulently procured. In view of the above, it can be ascertained that the exhibit 1 was validly executed by the defendant in favor of the plaintiff after taking the earnest money. That finding has been recorded, madam. On the other hand, it is also admitted by the defendant that the defendant number 1 executed exhibit A in favor of defendant number 2 on 1/4/2010. While evaluating exhibit 1 and exhibit A, it reveals that same plot of land was agreed to be sold by the defendant in favor of 2 different persons. Exhibit A was entered prior to exhibit 1. Next page. In view of the above and on the basis of discussion made above, it reveals that this is a fit and proper case where specific performance ought not to be ordered and a decree for compensation in lieu thereof would meet the aims of justice. Specific performance of an agreement need not necessarily be ordered merely because it is lawful to do so, and the matter. Exhibit A is the agreement for sale that was apparently executed between the defendant number 1 and defendant number 2. Yes. 1 is our agreement. Our agreement. Plaintiff's agreement with the defendant number 1. A is the between defendant number 1 and 2. Kulsum Bibi. Yes. A was between dependent, yes, same sale of, yes, between dependent number 1 and dependent number 2. Yes. Yes. Exhibit A1 was between dependent number 1 and the plaintiff. We sought for specific performance. Yes. And exhibit A was between dependent 1 and dependent number 2, Kulsum BP. Because defendant's case was, yes, defendant's case was that, yes, they never executed in two different agreement process. Yes, their case was that they never same plot of land. In view of the above, and on the basis of this, yes. Defendant. Owner was the defendant number 1. Yes. 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 That is his story. Defendant one story. His story was that he never executed any agreement for sale with the plaintiff. One with the defendant number 2. Yeah. Not plain. Para 25. In view of the above and on the basis of discussion made above, it reveals that this is a fit and proper case where specific performance ought not to be ordered, and a decree for compensation in lieu thereof would meet the ends of justice. Now, my lord, without recording any reason that since there as two agreements were executed over the same plot of land, the court said that this is not a fit case for specific performance and exercise this jurisdiction under section 20 of the specific relief act. Section 20 provides that the power to grant specific performance is discretionary, but that discretion must not be arbitrary. That part is missing in the judgment. There must be some clear finding that why specific performance in favor of the plaintiff was rejected and refused by the trial court. That reasoning must be there. That reasoning was not there in the judgment. Simply arbitrarily court said that no, it is not a fit case. Since the court has rejected the claim of the defendant, since this court has rejected the counterclaim, dismissed the counterclaim, madam. So, madam, the logical conclusion was that the suit of the plaintiff was also decreed also. Section 20. So, since the counterclaim was dismissed, that means, madam, the entire story is dismissed, madam. Entire story is rejected. That some different agreement for sale was there, because they also sought that declaration should be given that the defendant number 1 executed an agreement in favor of the defendant number 2. That part was also rejected. So if these parts are rejected, my lord, and the counterclaim was dismissed, then, my lord, the logical conclusion was that the agreement for sale should have been honored. Yes. My lord. While evaluating Exhibit 1 and Exhibit A, it reveals the same plot of land was agreed to be sold by the defendant in favor of two different persons. But that was not what was claimed by the defendant. His story was that he never executed any agreement for sale with the plaintiff. Had he said that he was in a hardship because there was only one plot of land, he executed two agreements, then it would have been, my lord, understandable. But he has, yes, 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 yes. So if his story was not believed, his entire story was rejected, my lord, then, my lord, since the suit was also decreed, the suit was clearly decreed. So if it was decreed, my lord, why, my lord, our reliefs were not granted? The relief that the specific performance could have been granted. Why that was not done? That was not there, my lord. This is not, my lord, my lord, what was there in the section 20. Section 20, my lord, if you lordship see, section 20, my lord, it says that the jurisdiction to decree specific performance is discretionary. And the court is not bound to grant such relief merely because it is lawful to do so. But the discretion of the court is not arbitrary. Here it is arbitrary, my lord. On one hand, you have already believed our story. On the other hand, my lord, you are not giving the relief which we are seeking. So definitely it is arbitrary, my lord. And my lord, it is also specifically says under what circumstances the court will not grant specific performance. The first is that, my lord, 28. It says where the terms of the contract or the conduct of the parties at the time of entering into the contract or the other circumstances under which the contract was entered into are such that the contract, though not voidable, gives the plaintiff an unfair advantage over the defendant. This is not the case. Second one is that where the performance of the contract will involve some hardship. So hardship has not been pleaded. The third is that where the defendant entered into the contract under circumstances which, though not rendering the contract voidable, makes it inequitable to enforce specific performance. Commentary. My lord. No. My only submission is that, my lord, if specific performance is not granted, since it is discretionary matter, then, my lord, the reasons must be anything between, my lord, the subsections, my lord, 1, 2, and 3. It must fall within either 21, 22, or 23. 120, yes. Here, my lord, hardship has not been pleaded by the defendant, my lord. So that cannot be a consideration, my lord, for refusing specific performance, my lord. The first one is, my lord, unfair, my lord, biasness, my lord. That is also not a case, my lord. And regarding iniquity, my lord, that is also not pleaded, my lord, by the defendant. So, my lord, if the suit is declared, my lord, so the logical conclusion is that, my lord, the specific performance ought to have been granted in our favor. That is my case. And the courts have not recorded any finding as to whether their case falls under 21, 22, 23. Nothing is there, madam. Simply it has said that no, it is not a fit case for specific performance. Recently also there is a Supreme Court judgment. If hardship has not been pleaded, then the party cannot take the plea of hardship in the appellate stage. But I can submit, madam. I will have to take a print. Yes. They cannot take the plea even in the appellate stage. They cannot take the plea in the appellate stage. They will have to take the plea. No, they have not taken it. It is not their case in the written statement also. Yes. Yes. Yeah. Yes. But that he has not taken. But he has not taken that plea, man. If he has said that the amount was very less, the sale consideration was less, then also it would have been understandable. That also he has not taken. He has not. He simply refused that, my lord, any agreement for sale was executed between him and the plaintiff. That part, my lord, it's not there, man. His story is that he had entered into a same agreement with defendant number 2. Yes. My document has been proved. Yes. Court will pass an order, my lord. I will place the judgment, my lord. The court master, my lord. My lord. My lord. Yes. 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 Today or another day. I can, my lord, at page number, my lord, 23. It starts from page number 23. And their case starts from page number 26. WS come counter claim. From page number 26, man. Yes. But their story is from page number 26. The earlier part, my lord, are only denials, my lord. Simple denial. Yes. That an area of land measuring 19 bigha 1 katha 9 lesa covered by Doug number 597, an area of land measuring 1 bigha 2 katha 9 lesas covered by Doug number 598 and an area of land measuring 4 bigha 1 kata 16 lessas covered by Dag number 708. All Dags are under Keras Periodi Patta number 430 and now 144. The total land measuring 25 bighas 14 lessas of village Goraimari under Moja Gilazari, which land is described herein as Schedule X land in the counterclaim. Schedule X land in the counterclaim is the name of the main defendant and pro forma defendant. So, my lord, this schedule, my lord, was Schedule A of our claim. So that, my lord, is Schedule X of their counterclaim. Total land, my lord, is same in both the schedules. Main defendant, pro forma defendants have right title, interest, and possession over the Schedule X land in the counterclaim. That out of Schedule X land measuring 25 bigha 15 lessas, a part of land measuring 1 bigha 1 kata 5 lessas covered by Dag number 597 under Kiras Periodic Patta number 144, the main defendant Muhibul Islam has right title, interest, and continuous possession as a legal heir of Pattada number 11, Muhammad Ali, bounded by so and so. So this 1 bigha 1 kata 5 lessa is the suit land. That is the Schedule X1 land of the counterclaim. The due X1 of the counterclaim. That due to urgent need of money, main defendant Muhibul Islam proposed to sell X1 schedule land measuring 1 bigha 1 kata 5 lessas to one Kulsum Begum, that is the defendant number 2, wife of Nurul Islam of Goraimari Gaon, for valuable consideration of rupees 1,37,000 only. Kulsum Begum also agrees to purchase the aforesaid land with the said amount of rupees 1,37,000, and on 1/4/2010, Muhibul Islam, the main defendant, entered into written agreement. Bainanama with the Kulsum Begum and furtherance of contract, Muhibul took amount of rupees 48,000 only from Kulsum Begum. Plaintiff know well regarding the said agreement Bainanama that the plaintiff and the main defendant have good relation among themselves. Muhibul Islam has been at Kolkata for higher studies. Thus, he was in urgent need of money to continue his studies. Muhibul Islam on 24/4/2010 came to the residence of plaintiff and requested to plaintiff to provide a temporary loan of rupees 20,000 and promised that the main defendant would repay the said amount immediately with interest. The plaintiff considered urgent need of money, handed over a cash amount of rupees 20,000, for which defendant Muhibul Islam signed blank non-judicial stamp paper of rupees 15 only to the plaintiff in presence of witness and handed over to the plaintiff. So, my lord, regarding the agreement for sale with the plaintiff, this is their story, that the plaintiff gave rupees 20,000 as loan to the defendant number 1, and in return he gave some signed stamp paper. That part was not believed by the court. That the defendant, para number E, that the defendant is an honest and innocent person by taking advantages of honest and innocent nature of defendant and sign non-judicial stamp paper. The plaintiff, influence of greediness for defendant's land, illegally and fraudulently executed the agreement for sale on 24/4/2010 on said blank non-judicial stamp paper in favor of plaintiff. So the defendant Muhibul Islam never executed any agreement for sale on 24/4/2010 and did not receive any amount of rupees 72,000 from the plaintiff. That part, he has clearly denied. For sale of the Schedule X1 land in the counterclaim and never filed any joint petition before the Deputy Commissioner to obtain sale permission in favor of plaintiff. Said permission was an illegal and fraudulent permission. So the sale permission which they jointly applied, that was also, my lord, refused by the defendant number 1. The defendant has no knowledge of the agreement for sale and sale permission in favor of plaintiff on 2/10/2012. When the plaintiff came to the Schedule X1 land and threatened to the defendant to vacate the Schedule X1 land and executed the registered sale deed on Schedule X1 land and said regarding the matter of the above mentioned suit. Thereafter, on 3/4/2013, yes, my lord, my lord, my lord. It is in, my lord, page number 14, my lord, page 14. One and three, my lord. 1 and 2 is also relevant. Yes. Right. Then my lord will fix a date. Fix it. My lord.
My lord, in this case, I am appearing on behalf of CM Mahanta, my lord. In this case, my lord, LCR received, my lord. LCR received, my lord, it may fix for hearing, my lord.
Lordship, I am appearing for response number 3, Lord. I may be served a copy of memo.
I'll say right now,
I have not yet received a copy of memo.
I'll say right now, my lord. Right. My lord.
1 and 2. Represent both.
To owner, my lord, owner is not represented, my lord. Owner no represented, my lord. His name may be 1.
Yes.
1 and 3, my lord. There are 3, my lord. Respondent, my lord.
I am for 3, Lord. There is no 4, I think.
No. 4, my lord.
Yes.
Yes. It will fix for hearing, my lord. Triple S Rahman. Triple S Rahman.
Three, Lord. M. Chaudhary, Lord. Mamuni Chaudhary. Number 3, Lord.
No, yeah. 2, 2, my lord. 1 and 2. LCR, my lord. LCR received, my lord.
Lordship, 1 and 2 deleted, Lordship, at the weeks of the claim appearance, Lord. Yes, Lordship. It is struck off, Lordship. That is their prayer, or their prayer, Lordship.
My lord, actually, my lord, lesson number 3 is a necessary party, my lord.
Because we are indemnifying the owner, Lord. We are the insurer, we are the indemnifier of the owner. At their weeks, Lordship, because they are praying for striking out the names. Yes, yes, that can be recorded. Yes, yes.
My lord. He's down now.
Yes, sir.
The first table, then I will take my lord.
Taken in the year 2020. Much obliged.
My lord, my lord, may I pray, a date may be fixed, my lord. A date may be fixed, my lord. Obliged.
Much obliged.
But I appear to have responded with 3 and 4. The earlier set of councils had withdrawn their brief from the petitioner. The earlier set of petitioners council. And in spite of notice that if your lordship sees, a affidavit was also filed by the council, which is at flag A. And there they have acknowledged that they have returned the file. The 3 and 4. No, but it seems they don't have any interest. From 21, 22 onwards, not they have not turned up. The records have been returned back long back. That is there in their affidavit. And then affidavit has also been filed by the council. But generally, in cases we don't file affidavit, but the council, my lord, bringing on record that they have written, my lord, to see an affidavit at the last, lord, where there is a flag A. But acknowledgement is there where the brief have been returned. So they are aware about that long back. Yes. কত মিনিট এটা পুরো বিটাই and brother and sister. Yeah. Well, they have filed the suit. They have not been granted injunction. They have filed an appeal before the yes. Against that, they have come before CRP. Yes. Yes, it is. I'm not going after the matter. I'm being engaged on the that. Yeah. Since they are not there, yes, then you lordship will fix a date. Let me indicate that there is no representation and Lord that affidavit is also. Yes. Yes, it's no. Three and four. Yes, yes. Yes, yes. Can it be a day later? But probably I'll be out of station. 21st.
May I please your lordship? I am the appellant on behalf of my seniors, K. Bhattacharjee. Lordship, LCR has been received a list of matter for hearing.
Lordship, I'm appearing for respondent number 3.
K. Ahmed. K. Bhattacharjee. K. Bhattacharjee. Lordship. Yes.
And second, Lordship. Respondent number 3.
If I have something to submit. My name is in the process for response number 2. But I have never filed the Vakrata for response number 2. In fact, there is no Vakratama in my name in the case record. In fact, my lord, I was also engaged for response number 3. Very interestingly, my name has been shown against response number 2. But there is no Vakratama in the case record. So they will appear, my lord, for response number 3. My name may not be shown in the constitution. Equally. Two. Yes. For response.
One's name is Prakhar. Lordship. Lordship. We do not. Well, we are for hearing. We do not want for the necessary check, but Lordship. Lordship. Yes. Yes. Lordship.
Okay.
My lord, service of respondent number 2 and 3 complete. Matter may be fixed for hearing. आइए तालुकदार for appellant.
SP Sharma for respondent number 1.
In NSC, having cross objection, I am for 2 and NSC appeal, I am for the response number 2. 2 and 3.
Yes, ma'am.
SP
In cross in appeal, respondent number 2.
My lord, if it is to 16 matters, if it is 24 or 25 March, if it is fixed.
Lordship, if possible, any time on April after Bihu vacation, we can try at least.
Oh, yes. Obliged.
Please, Your Honor. Your Honor, if I may take you, Your Honor, to order dated 26/4/2024. As per this honorable court. Your Honor, service upon respondent 1 and 2 has been completed, and upon 3 and 4 also steps had been taken, but notices have been returned back. And as per the order dated 26/4/2024, an observation was made by the honorable court that all the 4 respondents are from the same village in Rukmini Gaon in Dispur. So, and whatever address has been inserted in this case was taken from the case from the lower court, which the respondent number 1 had itself inserted in the lower court. So the honorable court had directed the counsel for the respondent to help us to get any new address of respondent 3 or 4, if any. But till now they have not provided any address. So we are unable to take any fresh steps upon them because the new address we are not aware of. जी कौशिक R Sensor. No, for R Sensor. जी कौशिक Public.
May I please? Lordship, in this matter, I'm seeking for some time to file the additional affidavit, Lordship. Lordship, I'm appearing for respondent number 2, 3, and 4 on behalf of MS Arch. F. Ahmed. F. N. Jaman. MS Arch Chaudhary for 2, 3, and 4. 3 and 4. Respondent number 1. Lordship, can it be after 4 weeks? Obliged.
Lordship, in the item number 19, there is a petition, delay petition, limitation petition. 495 days has been shown, but because of the suo motu order passed in WPC order, this call our period, we don't need to file even limitation petition.
But in fact,
Because 495 was, as you have, though we have counted it, in view of the order passed by Honorable Apex Court, this delay does not, we do not have that much of delay. So it's already a second appeal has already been, one second appeal has already been admitted, arising out of common judgment. That means we instituted the suit first. Our suit was decreed, there was a counterclaim was dismissed. Against that, they preferred only one appeal. Actually, there should have been a two appeal. That was not done. But by common judgment, first appellate court dismissed my suit and allowed their counterclaim. Against that, we preferred an appeal. That is RSA 117 of 2018. That has 2019. That has already been admitted by the Honorable Court by formulating substantive question of law. As against the counterclaim, we decided to have a second appeal. While preparing the second appeal, there is a delay of 495 days. But in view of the order passed by Honorable Apex Court, we do not have that delay. Therefore, I pray before this Honorable Court to condone the delay and admit this appeal also.
but if you Lordship would see the order sheet of this IA, which they are seeking confirmation of delay, but they have not been able to serve the respondent. That is the, in fact, the other case, I appear on behalf of the respondent, but the petitioners are well aware that, that we are the same council is appearing.
Lordship,
Not,
please go.
yes, I'm entitled to my submission. So, my lord, be that as it may, my lord, till date, there is no service of the I and the second appeal application upon. The orders is also reflect. Let my learned friend provide me a copy, I'll file an objection to it.
I'll provide you.
Or it may be given within the
Actually, the
2 weeks.
address which has been given in the plaint, or was the address in that original suit? That was same address was given.
That
I
is
don't
what,
know.
my lord, when I'm appearing in the same judgment, in the second appeal arising out of that, various orders have been passed by your lordship, my lord. It's but natural that one should contact the council if one service is not there. Anyway, my lord.
Lordship,
Let
I'll
my
serve the
friend-
copy. I'll serve the copy to him, both IA as well as appeal. DK Bhagavati.
Yes.
Lordship.
Provide me the copies of the I as well as second.
Lordship.
We'll be filing our objection within 2 weeks.
Appeal memo. Lordship.
I'll file an objection.
Lordship.
Notice is not required. I am appearing. Lordship only indicate that. Yes. 2 weeks.
Oh, good.
But page break can be given.
Lordship. Take copy.
Maybe not. But in this lordship, deal has been taken back by the respondent. Only for respondent. 8 months ago, it has been not present. Every settlement, husband and wife, my lord, came over.
May I please, your lordship. This item number 2, your lordship. It is in for 14, no? 12. Yes, but yes, my lord. My lord, since this is an announcement for against the insurance company, already award not required because it is between me and insurance. So it may come fixed for any date for. And date may be fixed for hearing. Madam. Yes, madam, 16 matter. 16. Oblige.
Lordship, N Duga. All the respondents except for 1-1 and 1-6. 1-6. Your- Lordship, I have a prayer to make. The last order was passed in 2023 and the appellants were supposed to file appropriate application for setting aside of the abatement. It was in 23, now it is 25. Lordship, may kindly record that this is the last opportunity that is given.
Yeah, please, Lord. My Lord, here, so many IA is there, my Lord. Lord, irregular second appeal, my Lord. There is a delay of 17 days in filing. Yes, my Lord. Yes, my Lord. But I will explain on to that, my Lord. Because in filing the regular second appeal, my Lord, there is a delay of 17 days. So we have filed delay application for 17 days. When notice has been served, then it comes to the notice that some of the respondents are already expired before filing of this regular second appeal. So accordingly, we have filed a substitution matter. But that substitution already time has been barred. So we have filed an abatement, and in that abatement also time is expired. Also, we have filed another limitation for the setting aside of abatement. In that Melod limitation, yes, this Melod 2981 Melod. Two 2981 Melod. Melod, in 2981 Melod, we are directed to serve notice upon respondent number 1, 2, 5, 6, 10, 1 and 10, 2. So Dusty. So accordingly, we have served from Dusty from report we have seen that Lordship may kindly see the affidavit we have filed regarding Dusty service in page 2. Page 2 of the affidavit page 2 page 2 para 2 May I read As per order dated 18/9/24 of this Honorable High Court, the applicant appellants have been allowed to take justice service to service of notice upon the respondent number 1, 2, 5, 6, 10, 1 and 10, 2. Therefore, deponent applicant number 6 has taken a step regarding the against the opposite party respondent number 1, 2, 5 and 10, 2. So Dusty, in compliance of the Honorable High Court order and step not taken against opposite party number 6 and 10, 1, my lord, because already their legal hair has been substituted, my lord. Their application has been filed, my lord, against these two respondents, 6 and 10, 1. So the Dusty was not taken. And I have died long back, and substitution petition has already been filed for implementation of their legal hair in this case. Also, during service of notice through Dusty, the deponent applicant number 6 comes to know that the respondent number 1, opposite party number 1, died on 5/3/2000, and her legal hairs are already party responding in the instant case.
Yes.
My lord, yes. Yes.
Yes, sir, Babu. For 3, 4, 7, 8, 10, 1, 10, 3, 10, 4, 10, 5, 10, 6, 10, 7, 10, 8, and 10. 7, 8, 10, 1, 10, 3, 2, 10, 10, 1, and 10, 10, 3, 2, 10, 9. Three, 10, 4, 10, 5, 10, 6, 10-7, 10-8, and 10-9.
My lord, respondent number one, against him already, her legal here is already party responding in the instant case. And regarding respondent number 2, 5 and 10, 2, they have died unmarried. Number 1, 2, 5 and 10, 2. 10, 2. Because others are already appeared, my lord. Only we are directed to serve only on this, my lord. 1, 2, 5, 6, 10, 1 and 10, 2. Now, my lord, 6 and 10, 1, they are already died and accordingly. Their legal has already filed of substitution petition has been filed. Other response.
No,
My lord, in the main limitation, which is filed in regular second appeal, in that case, my lord, newly substituted legal heir should be, my lord, notified again. Yes, that is in, my lord, in the delay petition, my lord, which is filed. No, my lord, there is 2 delay. One is, yes, in the abatement. So this is in this regarding this delay, my lord, already service is complete. Because 6 and 6, 10, 1, their legal heirs has already been substituted. Because, no, their substitution is not considered right now, my lord. It is still pending because abatement is there. First, we have to consider this, then the abatement petition, then come to the substitution petition, my lord. And regarding this, my lord,
Yes. If it is found that the other legal heirs are there, so require that track of. Yes. SR Board. Yes, sir. It has already, yeah.
then, my lord, this 2979 will come, my lord. This is for setting aside of abatement, my lord. The same explanation is there regarding delay, my lord. 2979.
Yes, happy. Yes. The phone number 3478 10 1 10 3 to 10 9.
Our respondent number, my lord. 6 and 10-1. 6 and 10-1, my lord. And 10-1, my lord. My lord, my lord, this 2979, this I is for, my lord, setting aside of abatement, my lord. Then 2977 is for substitution, my lord. Yes, 2977 substitution legal errors, my lord. No, no, yes. In filing the, my lord, the substitution petition, my lord. 6 and 10-1. Then, my lord, this, then, my lord, this 2977 will come regarding this substitution. Yes. Then, my lord, this, if this substituted, my lord, then 2147, it is a delay in the regular second appeal. So, in this I, yes, my notice has to be given. My lord, notice in regard to the respondent number 6 and 10-1. In IA, my lord, 2147.
My lord, notice maybe.
My lord, in this,
Yes.
yeah. Newly imputed respondent, my lord. And my lord, register may be directed to correct the, my lord, name of this, implement the name of the newly imputed substitute legal heirs in the legal, this 2147. Then only we can take the notice, my lord. In 2147. So, in the place of respondent number 6 and 10-1, my lord, this newly substituted legal heir will come. So, first we have to correct this, my lord, record, then notice has to be taken. Yes, yes, yes. Yes. Yes, ma'am. Ma'am. My lord, one more prayer. My lord. Yes, ma'am. One more prayer, my lord. If permit, we may be allowed to take justice in the newly implemented. Yes. Oblige.
May it please your lordship, my lord. Here also, my lord, this appeal was dismissed for non-prosecution, my lord. And since there is delay, my lord, I filed this I 3247 for continuation of the delay, and while issuing notice, my lord, that notice upon respondent number 1C is not completed. My lord, I have taken the instruction. He already expired, my lord, and his wife left the matrimonial house. Whereabout is not known. And my lord, he can be represented. Kindly see, my lord, 3247, my lord, IA, page 2. These other brothers are there, my lord. 1A, Giridhar Das, 1B, Nobin Das, 1C, he is expired, service not complete against him, therefore, return the Malot 80 with that remark. And number 2, Malot is also one of the brothers. So all the brothers are there. So in my humble submission, Malot, 1C may be struck off from the Malot area of the party, since he is already represented by the other legal heirs. And my lord, delay petition may be, my lord, taken up for consideration. Once. Yes, already, my lord, service completed. Others. Yes. Mine. First thing, that my lord, envelope has come with a remark, my lord. My lord, yes. My lord, yeah, other respondents, my lord, in fact, service completed, my lord. This is the, my lord, sir. That is there, my lord. My lord. My, my lord. 60/2024, my lord, that order 60, my, and thereafter, my lord, my lord. ठीक है दस मिनट my lord, his wife is has left the, my lord, matrimonial house, and she is whereabout is not known, and moreover, his interest can be, my lord, protected, my lord, by the other brothers. They are already represented in this case, my lord, on this. 1C can be represented by other respondents. They are the brothers. My lord, not, my lord, whereabout is not known, my lord. Yes. My lord, not known. My lord, yes. Condonation. 1C may be strike out, my lord. Accordingly, my lord. My lord, last occasion also they, after my lord dismissed for default, my lord, they are not represented, my lord. The new, whether this new, they are been newly engaged or not, my lord. My lord, delay is a little bit more, my lord, 2056 days. My lord, for hearing of this IM. As per convenience of lordship, my lord. My lord, last all the occasion there. Yes. Yes. Obliged. My lord, RSA was already admitted in this case, but my lord, for a non-prosecution, dismissed for default. My lord, therefore, we have filed this application for readmission of RSA restoration, my lord. Restoration.
Well, I for pondering the delay of 175 days in preparing the restoration petition. The CRP number 63 of 2023 was dismissed for non-prosecution, and I have already explained the ground as to why delay can be found.
There's no objection.
MDMS Sale.
M. Nar-
Especially, my lord, due to my non-prosecuted deputation court, due to my illness, I have elaborated in para number 4, and one leave petition was filed. My lord, this is 3322 and next one, restoration petition is filed. Civil division petition 63 2020. Failure. 175. Yes. One is 3322 is for limitation, that is condoning the delay, and the other is restoration, that is 3324. Restoration of the CIP. It's 2020.
Date may be fixed.
Item 38, they have filed. Item 38, they have filed for objection.
Yes, the lordship will file it on 6th of March, but then it has not been tagged along, and we have received the acknowledgement receipt. It was lying in the defect, the lordship. Now it has been tagged, so that the lordship can it be called for so that it can be taken up together today? Item 38, the last
File
one.
one IA for 50.
Okay.
Yes, Mother, in this matter, uh, regarding service, as per office note dated 2025, service has been completed and they have entered appearance, but name has not been reflected in the costing. So, Lordship may post the matter for admission hearing, the direction to reflect the name of the respondents. LCR is not required, ma'am. Not required, it is only a interim maintenance. Against the interim maintenance under section 24. Yes, no. Petitioner. Good. The date may be fixed, otherwise,
Made legal lordship. My lord, as per office note dated 6/3, my lord, the respondent had refused to receive the notice, my lord. So, my lord, no, not the respondent had refused, my lord. 6/3. 6/3. So, my lord, it may be deemed to have been served, my lord, because he has refused, my lord. And, my lord, lordship may fix the date for hearing. Actually, my lord, during the trial period also, she, as per page 23, my lord, she did not appear. Nothing लिखा है, it is written there. As per office note, matter it is written. There is him. What you may fix the date. No, no, man. Or fix April, man. April. Because man, she left the house, man, leaving two children, man. Not. Oblige, man.
Application. As per the last publication dated 19 to 25, service has been completed. Primary count for admission. T. Gogoi. Yes, ma'am.
UU Khan, respondent for 1 and 2.
TK Bhattacharya, woman advocate for respondent 3, 4, 5. Three, four, five.
19 to 2025. Six. By usual 4%. And this is the that Madam count for admission.
My lord, the NCR, they are questioning, my lord, will hear what the case is. They are questioning the sale deed, that is the main case. And the miss case against which they are coming is for dismissal of the claim by the defendant. So that is pretty serious from the government point of view. Yes. Admission hearing. So during admission hearing, my lord will see if possible to dispose of, and if the record is necessary, then my lord can call.
Oblige.
DK Bhagavati.
M. Hub. 1, 2, and 5.
Service is complete upon 3 and 4 also. Let them better come for episode hearing.
Congratulations, Lord. My Lord, as per provisional service report is completed, order dated 19 February 2020. Upon all the correspondence. Facility for episode hearing. Yes, my Lord. Order dated 19 to 2025. Additional hearing. Yes. Bhushan. All are brothers of the same.
My Lord, I'm from the petitioner side. The LCR is received and the respondent have also appeared before the court. Lordship, the case may be proceeded for admission here. SR Alam. Petition. Obliged, yeah. 34. G Kaushik. G Kaushik. For the applicant.
ये थोड़ा behalf of Mr. S. Dutta. S. Dutta. Only
I think it's not by file.
I has been disposed of. Here be
Your Honor, a date may be
come
fixed in the hearing
for
for the,
admission.
on 9th or 11th April. It would be 9th.
Of
Obliged.
Lordship, can we take a date on 11th April?
11th.
My senior will not get.
Obliged.
May it please the Lordship. Lordship, this matter has been listed wrongly today in the orders column. It should have come in the admission column, Lordship. Because as per the order passed in the IA for condonation of delay, Lordship, that is IA number 3233, it was clearly stated, Lordship. On the last occasion, the delay was condoned, Lordship. The order of the court was that the matter should be listed in the admission column. Somehow wrongly it has come up in the orders. In the IA number, Lordship, 3222, as per order dated 25/9/24. SP Sarma.
This IA has been instant IA has been filed in the disposed of IA, my lord. In the what has happened subsequent to the order passed in the IA at Annexure A page 12, my lord. There were three claimants originally. This relates to MEC appeal. Three claimants. One claimant number 3, Maijan Begum, expired after the passing of the order on 16/4/24 at page 15. The present application has been filed by his legal heirs as per the kin next of kin certificate as page 16. My lord will find the name of the heirs at is page 17, last page. This IA instant IA 3 at 7. 50% of the awarded money is lying deposited before the registry of this honorable court. So after the passing of this order in the IA, or dated 19/2/24, my lord, at page 13. No other person. And in fact, the main appeal has also been disposed of. Appeal was preferred by the insurance company that was dismissed in favor of the claimant. So, my lord, the only thing is to that the present applicants, the 4 applicants has filed this application to substitute Maijan Begum, and they may be allowed to withdraw the share of the Maijan Begum along with the other 2 claimants. Because
Actually, as the matter has already been disposed of.
Yes,
So,
yes.
Lordship, this 1 week time may be granted for the we may obtain.
my lord, with all humble respect, my lord, the matter is already disposed of. The
That is the
insurance company is no locus now at this stage. Only on the basis of this next of kin certificate, on the basis of the death certificate, the registry will verify my credentials. Only the legal hires may be allowed of the Maijan Begum. Other 2 legal hires who are already on record, Miss Sweetie Hussain, Kapoor Bey Hussain and Suhail Hussain, they have no objection if the share of the Maijan Begum is given to her legal hires. That is the issue, my lord. When since the main appeal is disposed of, insurance company is no locus now to object or to issue notice anything. What instruction you will obtain? Order is of 29/24. She expired on 16/4/24. Now we are into 25, my lord. Almost a year. More than a year has gone.
1 week period. Other than left to
Just for the sake of objecting, and what instruction I fail to understand, my lord. What instruction they will obtain? From whom they will obtain? The person has died, I have filed the death certificate, I have filed the next of kin certificate. The registry will verify my credentials. Had it been a pending matter, then the things would have been different. Main appeal has been disposed of. I will produce all the original death certificate and the next of kin certificate in original before the registry, along with my IDs and all. Three age expired, Maijan Begum. Yes, ma'am. At page 4, the name of the 4 applicants are there. They may be allowed to be substituted. No, Sweetie Kapoor and the grandson. Actually, the deceased was the son of the Maijan Begum, wife, husband of number 1, claimant number 1, and son, father of number 2. So 1 and 2 are already on their on record, and still, if even if the grandson is entitled in her share, they are waiving off. since I am the concern for the instruction, they are not objecting. If the other four, as per the kin certificate which they have obtained, if the share of the Maijan Begum is given to the four legal heirs, as per the kin certificate, the Chuti Kapoor and the Suhail Hussain has no objection. That may also be reported. They are claiming to the share of the Maijan Begum only. At page 4, my lord will find in of my application, at page 4. Ratul Hussain, Rubul Hussain, Babul Hussain, and Rukhsana Begum.
What is the judgment and order?
This, my lord, will find it page 13, my lord. Page 13. It starts from page 13, original, starts at page 12, post 13.
Page 13
Page
of,
13.
of the main
Of my IA.
I know that judgment, original judgment and order.
No, my lord. This application has been filed against the order passed in this IA. This IA is of 3040/2022. The 50% of the awarded amount was deposited. We made application for withdrawal of this. This petition was disposed of on 29 to 24.
No, but it's okay. But the main judgment and order, that share is divided
Main
between
judgment
them.
and order, my lord will find in the record itself. 199 of
In this
2020.
appeal, 50% is deposited.
Yes, regarding the rest of the 50%, there is no issue. The whole of the amount was issued, released in favor of the number 1 and 2 only. Maijan Begum is in 26 one. Regarding the 50%.
No, 50% has been deposited. 50% is yet to be deposited.
No, 50% is already.
Appeal is
given.
still pending.
No, disposed of.
Disposed of.
Disposed of, man. That is why I am saying, my lord. Otherwise, I would not have objected to his what he has submitted. The main appeal itself has been disposed of. Yeah, paragraph 8 of my petition, I have specifically stated that her entitlement will be rupees 8 lakhs and odd. Because original award was 53 lakhs and odd. In page 13, my lord will find page 13
So this appeal has been disposed of
on 29/4. Sorry, 24, 20th April. But I have made this application in IA 3040 of 2020. This 50% was deposited at the time of admission method. That has not could not be withdrawn because of her illness and all, and subsequently she passed away. Order was of 19/2/2024 and she expired on 16/4/2024.
Where is the other eye?
That
Against
is
which
3040, my lord.
3040.
40. That order will of 29/2/24.
Heard, Mr.
Ji Jalan.
So I'll pass an order then. Heard, Learned Counsel Mr.
Ji Jalan.
G. Jalan for the
Applicants.
application number 3871 for the applicants. These are the applicants, no?
Yes, my lord. At page 4. Ratul Hussain, Rubul Hussain,
For the applicants, Ratul Hussain,
Rubul
Rubul
Hussain,
Hussain, Babul Hussain, and Rukhsana Begum. Third Learned Counsel Mr. SP Sharma for the insurance company. The applicants have filed this application.
page 9 is my.
That this code by the order dated 29/2/2024 in IA number, the applications have filed this application nalage. It is submitted likhi. It is submitted by the on behalf of the applicants that this code by the order dated 29/2/2024 in IA civil number 3040/2020 22 directed the insurance company to deposit 50% of the awarded amount in connection with MSc case number 989 of 2017. Full stop. By judgment dated. When was the original judgment?
Original judgment is of 20 April 2024.
Not 2024. While judgment and award dated 6/3/2020, the learned member of MSCT, which place?
MSCT number 3 Guwahati.
Number 3, Guwahati, directed the insurer to pay rupees 53,83,744 with interest at the rate of 7.5% per annum to the claimants, comma, legal heirs of the deceased, full stop. It is submitted by the petitioners that the mother, Maijan
Begum, yes.
Maijan Begum, died on 16/4/2024. Full stop. Being legal heirs, they have paid for her share of rupees 8,45,936 only to be deposited, or only which
To withdraw, my lord.
to withdraw her share of rupees 8,45,936 to withdraw to void le hoye jabe. The judgment and order passed by the learned tribunal clearly reflects that out of the total awarded amount, rupees 20 lakh is to be kept as fixed deposit in the name of the minor claimant, Suhail Hussain, and a sum of rupees 12 lakhs is to be paid to Maijan Begum, mother of the deceased, and the remaining amount is to be paid to the
Wife.
claimant number 1, that is i.e. who?
Sweetie Kapoor Hussain.
Sweetie Kapoor Hussain. Full stop. The considering the submissions at the bar, the petitioners who have submitted the legal aid certificate and their
Death certificate.
and a death certificate of Maijan Begum along with this application are allowed to withdraw their share of rupees 8 lakh
8,45,936.
8,45,936 from the registry of this court. The registry is also the registry may also calculate the apportionment and also verify the documents submitted by the legal heirs of late Maijan Begum before and allow the and thereafter allow withdrawal of the amount of rupees 8 lakh so and so. In terms of the above observation, this application stands disposed of. Yes. 8 lakhs. See, the remaining amount will be taken by the other party only.
I 3040 to dispose.
Eto dispose hobo.
I 3871.
Dispose hobo. 3040 to agote dispose hobo. না ডিসপোজ করে আছে ওটা পাস করা আছে ডিসপোজ কৰা দেখাই দিবলৈ ক'বা।
Item 37.
Yeah, please. Also, we have taken steps. Then, official said that the service report may be awaited because
Learned Counsel Mr. Endeka.
M. Gogoi.
M.
Gogoi.
Gogoi is present on behalf of the appellants, stroke applicant. Service report on respondent number. Respondent. All respondent or sole respondent. Service report on the respondent is awaited. List the matter after 2 weeks. 2 weeks.
Fix a date.
Date the DD. All right.
All right.
Item 38.
May please, Your
Mm.
Honor. I have filed one IA in this case. They are the appellant before this court. I am the claimant, Lordship. Father of the deceased son, Lordship. My son died, and thereafter an award was passed, Lordship. There is a contributory negligence. Other insurance company had already deposited the amount. I have received the entire amount from the other insurance company. And this insurance company filed this appeal, and at the time of admission of the appeal, 50% was directed to be deposited. It is lying in the registry. So this IA for withdrawal.
Lordship, the main ground in the appeal is that we are not liable to pay, and the negligence was on part of only one vehicle.
Other insurance company has paid, deposited the.
Yes, Your Lordship. Your
Even if they have any objection, they can Lordship recover it from the other insurance company. They can.
If you may make my submission, so Lordship may please come to page 9 of the IA filed by the claimant, IA 419. This is the order passed in the state petition, Your Lordship. Since the connected appeal has been admitted for hearing, the award it is so and so passed by so and so shall remain state till disposal of the appeal, subject to 50% of the awarded amount, deposit of 50% of the awarded amount along with interest. In the registry of this court within 6 weeks, and the I stands disposed of. Your Lordship, we were only supposed to deposit the amount and no observation as to the withdrawal was made. First, Your Lordship. Secondly, Your Lordship, in the objection, which we have clearly stated, Your Lordship, the other claimant, that case was that the deceased was in a Tata Magic one vehicle, and there was a truck, second vehicle. So when the truck came and hit the first vehicle, the deceased who was the passenger in the first vehicle, he died. So they themselves have said that it was the negligence, rash and negligent driving of the driver of the truck. Secondly, Your Lordship, the eyewitness who was also co-passenger, he has also attributed the negligence only upon the truck. And the charge sheet, no doubt the names of drivers of both the vehicles are there in the charge sheet, but it was solely because of the involvement of two vehicles, but not because of the negligence of two vehicles. The negligence of the driver of the truck was proved. And so they have deposited. But what we are saying is our driver was not even liable to pay the compensation, Your Lordship. So at this stage, if the withdrawal is allowed, the entire purpose of the appeal would become infructuous, Your Lordship. Your Lordship, what I would like to propose before this honorable court is that a short date for hearing may be fixed, and if we are liable to pay, we'll pay the entire amount, because withdrawal at this stage shall not be permitted, Your Lordship.
Their allegation is against that insurance company, Lordship. But in fact, charge sheet was filed against the driver of both the vehicles, Lordship. Kindly come to page 12 of the appeal memo, Lordship. Internal page 6 and running page 12. Court paragraph CW1 court witness. Court witness Hemanta Sharma, then traffic in charge. Gauripur police station stated that the charge sheet number so-and-so dated 2016 has been submitted against both the driver of the truck bearing registration number so-and-so and the driver of the Tata Magic vehicle number so-and-so. He had prepared a report in this regard on 10/5/2016. Exhibit X is the said report bearing his signature. Exhibit X1 and Exhibit Y proved in original is the relevant page of the aforesaid Khatian containing particulars of Gauripur PS case number so-and-so. The charge sheet was filed under section 279-338-304A of IPC, he admitted to having received the FIR on 2010 and the charge sheet was filed on 2016, Lordship, after more than 6 years. Now it is evident from the evidence of CW1 that the charge sheet, the case followed the investigation that had been initiated on the FIR laws following the accident. The charge sheet as Exhibit X proved by CW1 had been filed against one Ghora Singh and one Abdul Alimur Sheikh, drivers of the offending truck and the Tata Magic vehicle respectively on 24/2/2016. There was no quashing petition against that charge sheet. Lordship. So they are admitted about the charge sheet, they have no grievance. Lordship. How can they raise that ground in a MSCT appeal? And I am the claimant, Lordship. I have a right to enjoy the fruit of the award.
Your Lordship, had the claimants not received any amount, we would have understood the application for the withdrawal. One of the insurance companies, the insurance company whose driver was actually liable, they have already received the amount in which they have withdrawn, Your Lordship. Now what we are saying is, Your Lordship, you are not even liable, and if the withdrawal is
You have withdrawn earlier amount.
No, that is from the debt insurance company, Lordship.
from the
This
insurer of the
insurance
truck.
company, only 50% was deposited before this registry, and I have a right to withdraw that amount, Lordship.
Your
It is
Lordship,
a deposited amount, Lordship.
Your Lordship, as far as the right to withdraw is concerned, it is only as per the discretion of the court, Your Lordship. Even in the order passed in the state petition, disposing of the state petition by Justice P.J. Sekia, no direction as to an application to be made for withdrawal. It was clearly stated that the amount shall be deposited till the disposal of the appeal, Your Lordship. What we are pleading is that
Maybe in
appeal
the
may be
state petition,
disposed
there was no prayer for withdrawal.
No, Lordship,
No,
state petition filed by them.
We filed the
They
state
filed, it
petition.
was admitted without the being noticed to the respondent. So it is not within our knowledge that the appeal was filed by the New India Insurance Company, Lordship.
The
When
appeal was
they
admitted
informed
only
before
after
the
the
executing court that they have filed one MST appeal, then only we came to know. Lordship. And then we filed our wakalatnama here and approached the registry for withdrawal of the same amount, Lordship. Then registry said, unless there is an order from court by filing an IA, Lordship, we cannot give that amount to you. So we filed this IA.
Your Lordship, if a short date is fixed, maybe next week, if a Lordship permits, then if we are held liable, then we'll then
No,
the
next
withdrawal
week,
will be
who will dispose and hold you liable?
Your Lordship, this
Final hearing of
Your
this
Lordship,
April
withdrawal at this stage
2017,
will be
Lordship.
contradicting the order passed in the state petition, Your Lordship. It will be contradicting the order of.
No,
a
no,
court.
normally,
Your
Lordship, normally, sometimes it has been passed as 50% to be deposited. And if the claimant come to withdraw the amount, a proper application can be filed or they may be allowed to. Such type of orders normally pass, Lordship.
Your
In this
Lordship,
case,
in the-
no such order was passed, so we have filed this interlocutory
Your
application.
Lordship, in the last month, there was a similar case before Justice Devashish Baru as well, Your Lordship, where an application for withdrawal was filed by the opposite party, and we said that a short date may be given for hearing, and if you are held liable, because Your Lordship, we can show you that we are not even liable. If you may please come to page 11 of the memo of appeal, Your Lordship.
Yes.
Page 11, the first paragraph, Your Lordship. In his cross-examination, PW1, Naushad Ali stated that on the objection raised by the National Insurance Company Limited, he had made New India Assurance Limited an opposite party in the claim petition. On the day of the alleged occurrence, his son was traveling in Tata Magic passenger vehicle. He had heard the offending truck had hit the Tata Magic from behind, resulting in the death of his son in the said accident. Firstly, Your Lordship, we were not even made a party. Only when the insurer of the other vehicle, whose money they have already withdrawn, opposed it, we were made a party in that case, Your Lordship. Firstly. Secondly, in the claim petition, they themselves have said that his son was in the Tata Magic and the truck has hit him, and so he died. Your Lordship, the next paragraph, PW2. PW2, Abu Bakr Siddiqui stated to have accompanied his nephew Hanif Ali along with his elder brother Hazrat Ali from so-and-so in Tata Magic bearing registration number so-and-so and they were on their way to the house of Hazrat Ali. On their way, a truck bearing register number so and so knocked the backside of the Tata Magic. Even PW2, who was a co-passenger, stated the same thing, Your Lordship. Now, Your Lordship, even PW3, these are the witnesses produced by the claimant side, Your Lordship. They themselves are saying that it was the truck who hit the Tata Magic. Your Lordship may come to the last paragraph of this page, PW3. Your Lordship, may I read? PW3, Hazrat Ali stated in his evidence that he had accompanied his nephew, Hanif Ali, on so and so in a Tata Magic bearing registration number so and so on his way to his house. A truck number so and so, due to rash and negligent driving of the driver, had knocked the backside of the Tata Magic.
You are an appellant in this case?
Yes, Your Lordship.
When will you hear the, when will you
Whenever Your Lord, as per Your
yes, or
Lordship
submission?
says,
Okay, we'll fix it for
Lordship,
hearing then.
One thing, they are raising one point that they were implicated at the instigation of the other insurance company. But when they were implicated, Lordship, it is a case of make appeal of 2010 and judgment was delivered on 17/3/2017. So before 2017, they were implicated. They remain silent without challenging that impleadment order, Lordship. They have raised objection before there or not in their written statement. That written statement also not annexed along with the appeal.
Your Lordship, all this
Only
will be
on
taken
this
back to
ground,
stage of hearing, Your Lordship.
only
You
on
can
this
produce all
ground,
the
your
documents.
lordship cannot reject this IA.
I'm not rejecting it. We'll fix it. We'll take it up together, and then we'll decide the
Lordship
appeal.
knows that final hearing of the
So we'll fix a
2017.
date.
Yes, Your Lordship.
Fix a date.
Fix
But
it
if your
at
Lordship-
2 p.m. Lordship.
Yes, at 2 p.m.
Next week, Lordship.
Both the parties are represented. List this matter for hearing on 27th of March, positively, without pain.
Can it be on 17 March? Lordship?
Yes. No, not possible on 17th. 27 March.
24th March, Lordship.
24th? Not on 24th. 27 at 2 p.m.
Today is only 13, Lordship, so it will go after 2 weeks.
27 at 2 p.m.
27 at 2.
Positively.
Lord.
Please place your submission.
Yes, Lord.
We'll dispose of this case.
Much of your
If not me, somebody else will dispose of this case.
Lordship. Obliged.
Mm. Mm. Mm.
Supplementary is item 41. May I please, Your Honor? This is a IA for a direction to release the 50% amount that has already been deposited before the registry. Lordship. They filed this appeal, Lordship, basically on quantum, Lordship. Quantum, Lordship. So I think, Lordship,
I think he has no objection. Do you have any
That's
objection?
we want to file objection, because the main ground here is because there was.
You will file retail objection.
what objection, Lordship?
Why not?
We have filed it, Lordship, till 2025. More than one.
Heard learned counsel Mr. M. Khan for the appellant stroke applicant. Heard Mr. SP Sharma. SP Sharma, learned counsel for the insurance company, who has submitted that he will file objection against this application. List this matter on
18.
Huh?
18.
18th. দিব পাৰি objection দিব আকৌ এটা লিখিলে learned counsel Mr. C.R. Padres, K.R. Padres present for the opposite party stroke respondent number 2 and 3.